Court is now back in session. Good afternoon, Your Honor.
Good afternoon. And In re Kuna may have the appearances of the parties, please, starting with the Chief Disciplinary Counsel.
Good afternoon, Your Honor. I am Brian Staines, Staines, Chief Disciplinary Counsel.
Good afternoon.
Norm Pattis on behalf of Ms. Kuna, Judge.
Good afternoon.
Good afternoon, Your Honor. Corinne Boni-Vendola, trustee.
Good afternoon.
Good afternoon, Your Honor. Nicole Acuna, I am present.
Good afternoon. All right,
Thank
Ms. Pattis, Mr. Pattis, you were going to report on the status of efforts to raise the funds for the matter we've been discussing. Could you bring me up to date, please?
Yes, sir, and thank you for permission to participate audio only. I'm not 100% sure, but I think we may have the problem solved. It appears as though Ms. Cuna's insurer may be willing to fund an evaluation so long as that evaluation is not characterized as a competency hearing. And she has made contact with the evaluator. So we are preparing to proceed with the evaluation. Because the insurance picture is uncertain, I think I would recommend the court keep us on a tight leash with a relatively quick report back, because if the insurer backs out for some reason, you'll want to know that.
What are you proposing?
1 week.
Mr. Staines will hear you.
I have two issues I think we should resolve today. Before I believe we go forward, I need some more information so I can evaluate the process that's going to happen as to the name of the doctor who's going to be doing it. And I think more importantly, I think we have to nail down what exactly we're trying to accomplish with this. Initially, Attorney Pattis raised the issue under Connecticut General Statute Section 54-56D. That relates in criminal cases to competency to stand trial. And the issue on that the only issue that has to be resolved for that is whether or not a defendant is competent in that she's unable to understand the proceedings against her or assist in her own defense. That's the competency to stand trial. Throughout this process that we've been using, Mr. Pattis has alternatively phrased it as she was incompetent or her competency is questioned in that she couldn't willfully or she couldn't control her ability to comply with the court order, and therefore, with regard to the order, the finding of contempt, it wasn't a willful failure. And that's something that's completely different than the competency issue on competency to stand trial.
Well, it is a different thing, but I made it clear what the issue in front of me was. It was the question of whether she's in contempt of the court orders, and one defense that can be raised to a contempt of as such, where the burden would be on Ms. Kuna to prove, is that she's unable to comply with the court's order. And if some condition makes her unable to comply with the court's order, then I had indicated to Mr. Pattis that I'd give him the opportunity to put evidence on with that. So that's the way it's framed in my mind. It is not the same thing as 54-56D. It's very much about the court's civil order in this case, and whether it's whether the Ms. Kuna is in contempt of that order. So I hope that clarifies that much at least. And then, Mr. Pattis, I think you previously named who the physician is. Do you have something that you can send to Mr. Staines and Ms. Boni-Vendola concerning the person's qualifications?
Yes. Well, I don't, but I can obtain it. Yes.
All right. So if we take a week, then one of the first things you'd need to do is to provide that to Mr. Staines so that Mr. Staines can determine if he wants to raise some. Well, of course, Mr. Staines, it can be done, and then you can object to my considering it because you don't think that it's in some way qualified. But I don't think we need to have a second step here for you to object to the person getting time to do it. You might simply object to the qualifications and say I should disregard the opinion. So I think that's the way to do it. And that would give us a week to do that. Is there anything else, Mr. Staines, that you want to bring up?
No, sir, I have nothing else.
Or Mr. Patterson, anything else?
No, sir.
Anything, Ms. Bonnie Vendola, that you want to raise?
No, Your Honor, not at this time.
I have one question, Mr. Staines, for you, and maybe for Mr. Pattis, because this was another thing that was raised in connection with the discussion of 5456D. And that is, Mr. Staines, are you aware of, is there any involvement, because there's been a Fifth Amendment claim and other things here, that is there any activity in the state's attorney's office about concerning this that I should be aware of, that you know of? Have you had any communication with them?
I have not had any communication with the Connecticut State's Attorney's Office regarding Ms. Cunha generally.
About any aspect of it? About Ms. Cunha in any way?
Well, the state's attorney, the Connecticut State's Attorney's Office did contact me to provide me some information unrelated to what we're talking about now.
Oh, all right. It's unrelated to, if it's unrelated to this proceeding, or, well, not to this proceeding, but unrelated to activities related to her disbarment, and I don't care. I just wanted to. Now, Ms. Pattis, you don't have to say anything about this subject if you don't want to.
I've not had any contact, sir. No one has contacted me from that office.
All right. Assuming then there's nothing else for us to discuss at this stage, then thank you all for your cooperation, and court's in recess.